Readable ba?
Yes, ma'am.
ML. Okay. So for today, we will be discussing rules on electronic evidence. Hindi natin uh, isa-isahin, pero piliin lang natin kung ano yung mga applicable para sa atin. So, the rules on electronic evidence is AM number Administrative Memo number 01-7-01-SC. Okay, so this is the rules on electronic evidence. Okay, so this took effect in, these rules shall take effect on the first day of August 2001 following their publication. Okay, so 2001 pa ito. Rules on electronic evidence, Rule 1 coverage. So the scope is unless otherwise provided herein, these rules shall apply whenever an electronic data message, as defined in Rule 2 hereof, is offered or used in evidence. Because during this time, di ba, hindi pa tayo masyadong alam niyo naman ng Pilipinas, hindi pa tayo gano'n ka-advance, kaya parang bagong bagay kapag electronic evidence. Kaya ayun, 2001 lang siya. Okay, so the cases covered, these rules shall apply to all civil actions and proceedings as well as quasi-judicial and administrative cases. And then the application of the other rules on evidence in all matters not specifically covered by these rules, the rules of court and pertinent provisions of statutes containing rules on evidence shall apply. So, kapag hindi nakikita dito, or hindi siya nabanggit dito sa administrative memo na ito, then the rules of court will be applied. Okay. So, definition of terms, piliin lang natin yung applicable. Computer siguro naman, alam nyo na yan. Na-discuss na rin natin yan dati. Ito, digital signature. This refers to an electronic signature consisting of a transformation of an electronic document or an electronic data message using an asymmetric or public crypto system. A public, ito, itong asymmetric or public crypto system is a system capable of generating a secure pair consisting of a private key for creating a digital signature and a public key for verifying the digital signature. Yung key pair na yan, para siyang, sabi nga, merong private key and public key. Yung public key, yun yung nag-encrypt ng isang document, and then yung private key is used to decrypt para makuha mo kung ano yung in-encrypt. Okay, balik tayo dito. Digital signature such that a person having the initial untransformed electronic document and the signer's public key can accurately determine whether the transformation was created using the private key that corresponds to the signer's public key, and whether the initial electronic document had been altered after the transformation was made. Okay. Digitally signed refers to an electronic document or electronic data message bearing a digital signature. Kaya nga siya digitally signed. And then electronic data message refers to information generated, sent, received, or stored by electronic, optical, or similar means. Then electronic document is refers to the information or the representation of information, data, figures, symbols, or other modes of written expression described or however represented by which a right is established, an obligation extinguished. So parang sa QD lang din. Ang kaibahan, gumamit ng ganito. It is generated, sent, received, or stored by electronic, optical, or similar means. Yun lang yung kaibahan sa ganitong klase ng document. Ito, letter K, ephemeral electronic communication. This refers to telephone conversations, text messages, chat room sessions, streaming audio, streaming video, and other electronic forms of communication, the evidence of which is not recorded or retained. Okay. Okay. And then dito tayo sa Rule 3. Electronic documents. Section 1, electronic documents as functional equivalent of paper-based documents. So whenever a rule of evidence refers to the term of writing, document, record, instrument, memorandum, or any other form of writing, such term shall be deemed to include an electronic document as defined in these rules. Ang ibig lang sabihin dyan, kung papaano natin nire-regard ang isang document na hard copy, kung ano yung kahalagahan niya, kung papaano siya i-treat, ganun din ang paraan at ganun din yung pagtrato natin sa mga electronic documents. Admissibility. An electronic document is admissible in evidence if it complies with the rules on admissibility prescribed by the rules of court and related laws and is authenticated in the manner prescribed by these rules. Katulad nga nung nasabi natin kanina, kung papaano natin nire-regard ang isang hard copy, isang papel na document, ganun din ang electronic document. Kung ano yung procedure sa pagtanggap sa isang papel bilang isang document, bilang isang ebidensya, ganun din sa electronic documents. Okay? And then privileged communication. The confidential character of a privileged communication is not solely on the ground that it is in the form of an electronic document. So, hindi porket electronic document ang isang document ay agad-agad mako-consider ito na privileged communication. Ewan ko kung natakil niyo na yan, but privileged communication are those of between the lawyer and the client, the priest and the confessee, the doctor and the patient, yung mga yun. Okay. Best evidence rule. So, original of an electronic document. Parehas lang din sa napag-aralan natin sa QD. The best evidence is always the original. So, an electronic document shall be regarded as the equivalent of an original document under the best evidence rule if it is a printout or output readable by sight or other means shown to reflect the data accurately. Okay. And then, copies as equivalent of the originals when a document is in two or more copies executed at about the same time with identical contents or is a counterpart produced by the same impression as the original or from the same matrix or by mechanical or electronic re-recording or by chemical reproduction or by other equivalent techniques which reproduces the original, such copies or duplicates shall be regarded as the equivalent of the original, notwithstanding the foregoing. Copies or duplicates shall not be admissible to the same extent as the original if a genuine question is raised as to the authenticity of the original. So, yun nga, same lang sa mga napag-aralan natin sa QD. And in the circumstances, it would be unjust or inequitable to admit a copy in lieu of the original. Okay, Rule 5, authentication of electronic document. So, sino ang may burden para patunayan na ang isang document ay authentic? So the person seeking to introduce an electronic document in any legal proceeding has the burden of proving its authenticity in the manner provided in this rule. So whether you are in the prosecution or you are in the defense, kung sino ang mag-a-admit ng evidence, siya ang may burden of proof. Hindi katulad sa pagiging guilty ng isang accused. Ang may burden of proof doon is the prosecution, hindi ang defense, kasi nga defense lang siya. But, yun na, in electronic documents, kung sino yung mag-a-admit nun as evidence, siya ang may burden of proof. And then manner of authentication, papaano ginagawa yon? Before any private electronic document offered as authentic is received in evidence, its authenticity must be proved by any of the following means. First is by evidence that it had been digitally signed by the person purported to have signed the same, by evidence that other appropriate security procedures or devices as may be authorized by the Supreme Court or by law for authentication of electronic documents were applied to the document, or by other evidence showing its integrity and reliability to the satisfaction of the judge. So yun, pwede ka pa rin umasa kay judge na ah, tanggapin niya yung evidence, yung electronic document na yon dahil naging sapat yung mga pinakita mong patunay or evidence nga na legit talaga or authentic yung isang document. Okay. Proof of electronically notarized document. A document electronically notarized in accordance with the rules promulgated by the Supreme Court shall be considered as a public document and proved as a notarial document under the rules of court. If you can remember, ang isang document kapag hindi siya notarized, it's private. But when a certain document has actually notarized, it becomes a public document. Pero, kung maalala nyo hindi lahat ng public document ay official document. Pero lahat ng official ay public. This is because of, yun sa pagno-notarize. Kasi yung affidavit of loss, kapag pinanotaryo mo, nagiging public document. But it is not an official document. Yun, example niya. Okay? Rule 7, evidentiary weight of electronic documents. So, section 1, factors for assessing evidentiary weight. Gaano ba kabigat yung ebidensya na to? Gaano ang mako-contribute niya doon sa case na ongoing? So, in assessing the evidentiary weight of an electronic document, the following factors may be considered. Reliability of the manner or method in which it was generated, stored, or communicated, including but not limited to input and output procedures, controls, tests, and checks for accuracy and reliability of the electronic data message or document in the light of all the circumstances as well as any relevant agreement. Then reliability of the manner in which its originator was identified, kung papaano natukoy yung original. And then the integrity of the information and communication system in which it is recorded or stored. Katiwa-tiwala ba yung lagayan kung saan nga naka-record or naka-store ang document. And then including but not limited to the hardware and computer programs or software used as well as programming errors. So pati yun titignan kung may integrity ba. Kasi kung sabihin na natin compromised yon or hindi nga gaano kaganda or yung integrity nga niya hindi masyadong ma-accept, then medyo hindi magiging mabigat yung ebidensya na yun. Kasi may doubt. The familiarity of the witness or the person who made the entry with the communication and information system. The nature and quality of the information which went into the communication and information system upon the electronic data message or electronic document was based. Or other factors which the court may consider as affecting the accuracy or integrity of the electronic document or electronic data message. Why is it na kumbaga, ang daming points nung integrity? Kasi kung compromised ang isang document, magdududa ka eh. Parang yung kaklase niyong mamulachi talaga, kilala niyo siya mula first year, talagang mamulachi siya. Kaya pag sinasabi niya, ako may bago na naman akong cellphone at saka yung motor ko bago na naman. Parang hindi ka naman maniniwala kasi na-compromise na nga yung integrity niya. Ganun din sa ebidensya. Okay. Section 2, integrity of an information and communication system. In any dispute involving the integrity of the information and communication system, in which an electronic document or electronic data message is recorded or stored, the court may consider, among others, the following factors. So first is whether the information and communication system or other similar device was operated in a manner that did not affect the integrity of the electronic document, and there are no other reasonable grounds to doubt the integrity of the information and communication system. Then whether the electronic document was recorded or stored by a party to the proceedings with interest adverse to that of the party using it, or whether the electronic document was recorded or stored in the usual and ordinary course of business by a person who is not a party to the proceedings and who did not act under the control of the party using it. Okay. Rule 9, method of proof. So first is affidavit of evidence. All matters relating to the admissibility and evidentiary weight of an electronic document may be established by an affidavit stating facts of direct personal knowledge of the affiant or based on authentic records. The affidavit must affirmatively show the competence of the affiant to testify on the matters contained therein. Okay. So, kailangan kung sino yung affiant ay may direct personal knowledge siya tungkol dun sa evidence na ipinapasok ninyo for that specific case. And then cross-examination of deponent. The affiant shall be made to affirm the contents of the affidavit in open court and may be cross-examined as a matter of right by the adverse party. Usually naman ganun, 'di ba? Talagang may cross-examination pati sa ah, civil cases at hindi lang naman 'yun applicable sa mga criminal cases. Okay? Sige, 'yun muna for today.